One of the most promising areas for the growth of third-party litigation funding is in cases that involve an insolvent party who has assets, including valuable legal claims, that lacks the ready cash to pursue. A recent Canadian decision demonstrates that the use of third-party funding can expedite the resolution of the insolvency process and that it can bring about a more just result for everyone involved. It is easy to see how litigation funding can help insolvent parties. In many cases, the playing field for litigation is very uneven when one party is insolvent. Such parties are at the mercy of their creditors because of their insolvency, and they must surrender assets on unfavorable terms. Alternatively, they must sometimes accede to the demands of one creditor, even if that accession unfairly infringes on the rights of other creditors with inferior rights. In Quebec Inc., Blueberry Gaming Technologies Inc., 2018 QCC S1040, an insolvent company was operating under court protection in a Companies Creditors Arrangement Act. It wanted to pursue a significant claim against its primary secured creditor, but it needed funding from a third party to pay its legal fees in connection with that claim. The litigation funding agreement stipulated that the third-party litigation funder would pay all legal fees and disbursements required for proposed claim in exchange for a portion of any proceeds of the litigation. The court approved the agreement. In reaching its decision, it ruled that, under Canadian law, third-party funding agreements should be approved, subject to the following principles. The provision of funding from a third party must be necessary to provide to a plaintiff access to justice. The agreement should make it clear that the plaintiff retains the complete power to instruct and control the litigation. The third-party funding agreement must not compromise or impair the lawyer and client relationship or the lawyer's duties of loyalty and confidentiality. The compensation of the third-party funder must be fair and reasonable, and the third-party funder must preserve the confidentiality of any confidential or privileged information. Litigation financing is valuable because, among other things, it facilitates access to justice for parties who lack economic power. It is, or should be, axiomatic that the merits of a legal dispute should not be determined by the relative economic power of the parties. This is a particular problem in the insolvency context. But in this context, as in so many others, litigation finance offers a solution that promotes the interests of justice.